The Muslim Family Laws Ordinance 1961. Ordinance number 8 of 1961. An ordinance to give effect to certain recommendation of the Commission on Marriage and Family Laws. Whereas it is expedient to give effect to certain recommendation of the Commission on Marriage and Family Laws, now therefore in pursuance of the proclamation of the 7th day of October 1958 and in exercise of all powers enabling him in that behalf, the President is pleased to make and promulgate the following ordinance. Section 1. Short title, Extent, Application and Commencement. Subsection 1. This ordinance may be called the Muslim Family Laws Ordinance 1961. Subsection 2. It extends to the whole of Bangladesh and applies to all Muslim citizens of Bangladesh wherever they may be. Subsection 3. It shall come into force on such date as the government may, by notification in the official gazette, appoint in this behalf. Section 2. Definitions. In this ordinance, unless there is anything repugnant in the subject or context. Clause A. Arbitration Council means a body consisting of the chairman and a representative of each of the parties to a matter dealt with in this ordinance. Provided that where any party fails to nominate a representative within the prescribed time, the body formed without such representative shall be the Arbitration Council. Clause B. Chairman means subclause 1. The chairman of the Union Parishad. Subclause 2. The chairman of the Paurasabha. Subclause 3. The mayor or administrator of the municipal corporation. Subclause 4. The person appointed by the government in the cantonment areas to discharge the function of chairman under this ordinance. Subclause 5. Where the Union Parishad, Paurasabha, municipal corporation is superseded, the person discharging the function of such Parishad, Paurasabha or corporation, or as the case may be, appointed by the government to discharge the function of chairman under this ordinance. Provided that where the chairman of the Union Parishad or Paurasabha or the mayor of the municipal corporation is a non-Muslim or he himself wishes to make an application to the Arbitration Council or is owing to illness or an other reason unable to discharge the functions of chairman, the Union Parishad, Paurasabha or municipal corporation shall elect one of its Muslim members or commissioners as chairman for the purposes of this ordinance. Clause C. Municipal Corporation means the municipal corporation constituted under the Chittagong Municipal Corporation Ordinance 1982. Or the Dhaka Municipal Corporation Ordinance 1983, Act number 40 of 1983, or the Khulna Municipal Ordinance 1984, Ordinance number 72 of 1984, and having in the matter jurisdiction as prescribed. Clause D. Paurasabha means the Paurasabha constituted under the Paurasabha Ordinance 1977 and having the matter jurisdiction as prescribed. Clause E. Prescribed means prescribed by rules made under Section 11. Clause F. Union Parishad means the Union Parishad constituted under the Local Government Union Parishad Ordinance 1983. Ordinance number 51 of 1983 and having in the matter jurisdiction as prescribed. Section 3. Ordinance to override other laws, etc. Subsection 1. The provisions of this ordinance shall have effect notwithstanding any law, custom or uses. Subsection 2. For the removal of doubt, it is hereby declared that the provision of the Arbitration Act 1940, the Code of Civil Procedure 1908, and any other law regulating the procedure of civil of courts shall not apply to any arbitration council. Section 4. Succession. In the event of death of any son or daughter of the propositas before the opening of succession, the children of such son or daughter, if any living at the time the succession opens, shall per stripes receive a share equivalent to the share which such son or daughter, as the case may be, would have received if alive. Section 6. Polygamy. Subsection 1. No man during the subsistence of an existing marriage shall, except with a previous permission in writing of the arbitration council, contract another marriage, nor shall any such marriage contracted without such permission be registered under the Muslim Marriages and Divorces Restraint Act 1974. Act number 52 of 1974. Subsection 2. An application for permission under subsection 1 shall be submitted to the chairman in the prescribed manner, together with the prescribed fee, and shall state the reason for the proposed marriage and where the consent of the existing wife or wives has been obtained thereto. Subsection 3. On receipt of the application under subsection 2, the chairman shall ask the applicant and his existing wife or wives each to nominate a representative, and the arbitration council so constituted may, if satisfied that the proposed marriage is necessary and just, grant, subject to such condition if any, as may be deemed fit, the permission applied for. Subsection 4. In deciding the application, the arbitration council shall record its reason for the decision, and any party may, in the prescribed manner, within the prescribed period, and on payment of the prescribed fee, prefer an application for revision to the assistant judge concerned, and his decision shall be final and shall not be called in question in any court. Subsection 5. Any man who contracts another marriage without the permission of the arbitration council shall, Clause A, pay immediately the entire amount of the dower, whether prompt or deferred, due to the existing wife or wives, which amount, if not so paid, shall be recoverable as arrears of land revenue, and Clause B. On conviction upon complaint, be punishable with simple imprisonment, which may extend to 1 year, or with fine, which may extend to 10,000 taka, or with both. Section 7. Talaq. Subsection 1. Any man who wishes to divorce his wife shall, as soon as may be after the pronouncement of talaq in any form whatsoever, give the chairman notice in writing of his having done so, and shall supply a copy thereof to the wife. Subsection 2. Whoever contravenes the provision of subsection 1 shall be punishable with simple imprisonment for term which may extend to 1 year, or with fine which may extend to 10,000 taka, or with both. Subsection 3. Save as provided in subsection 5, a talaq, unless revoked earlier expressly or otherwise, shall not be effective until the expiration of 90 days from the day on which the notice under subsection 1 is delivered to the chairman. Subsection 4. Within 30 days of the receipt of notice under subsection 1, the chairman shall constitute an arbitration council for the purpose of bringing about a reconciliation between the parties, and the arbitration council shall take all steps necessary to bring about such reconciliation. Subsection 5. If the wife be pregnant at the time talaq is pronounced, talaq shall not be effective until the period mentioned in subsection 3 or the pregnancy, whichever be later, ends. Subsection 6. Nothing shall debar a wife whose marriage has been terminated by talaq, effective under this section, from remarrying the same husband without an interfering marriage with a third person, unless such termination is for the third time so effective. Section 8. Dissolution of marriage otherwise than by talaq. Where the right to divorce has been duly delegated to the wife, and she wishes to exercise that right, or where any of the parties to a marriage wishes to dissolve the marriage otherwise than by talaq, the provision of section 7 shall mutadis mutandis as and so far as applicable apply. Section 9. Maintenance. Subsection 1. If any husband fails to maintain his wife adequately, or where there are more wives than one, fails to maintain them equitably, the wife or all or any of the wives may, in addition to seeking any other legal remedy available, apply to the chairman, who shall constitute an arbitration council to determine the matter, and the arbitration council may issue a certificate specifying the amount which shall be paid as maintenance by the husband. Subsection 2. A husband or wife may, in the prescribed manner, within the prescribed period, and on payment of the prescribed fee, prepare an application for revision of the certificate to the assistant judge concerned, and his decision shall be final and shall not be called in question in any court. Subsection 3. Any amount payable under subsection 1 or 2, if not paid in due time, shall be recoverable as arrears of land revenue. Section 10. Dower. Where no details about the mode of payment of dower are specified in the nikahnaama or the marriage contract, the entire amount of the dower shall be prescribed to be payable on demand. Section 11. Power to make rules. Subsection 1. The government may make rules to carry into effect the purposes of this ordinance. Subsection 2. In making rules under this section, the government may provide that a breach of any of the rules shall be punishable with simple imprisonment, which may extend to 1 month, or with fine, which may extend to 500 taka, or with both. Subsection 3. Rules made under this section shall be published in the official gazette and shall thereupon have effect as if enacted in this ordinance. Section 11a. Place of trial. Notwithstanding anything contained in any other law for the time being in force, an offence under this ordinance shall be tried by a court within the local limits of whose jurisdiction, Clause A, the offence was committed, or Clause B, the complainant or the accused resides or last resided.